Docket number SJC-13369, Commonwealth versus Franklin Conza.
Okay, Attorney Smith.
Good morning. May it please the court, my name is William Smith. It's my privilege to represent Mr. Conza. I apologize in advance. I'm getting over an upper respiratory infection and an ear infection, so I speak loudly.
We have some feedback happening.
Which I'm sure has nothing to do with your...
With my loud voice.
Okay.
All right, let's try again. Go ahead.
Thank you very much. So I apologize if I do speak loudly at points. Your Honors, I would suggest with respect to the jury selection issue here, this case illustrates perhaps as good as any could the principle that even discretion, a judge's discretion, is subject to outer legal parameters. So of course, what happened here, the judge asked the question of juror number 24, for whatever reason, do you think Hispanics may commit crime more frequently than other members of other groups? And juror 24 responded, I would say maybe in certain areas, but I don't know. I would suggest, of course, that alone is, to put it mildly, requires that the protocol under Williams be followed. But then the judge asked asked juror 24 to repeat that. Then juror 24 said, I want to say maybe in certain areas, but no. So it sort of changed from I don't know to then the juror is saying no. And I would suggest that is indicative of the fact that the juror is sort of then in the position of wanting to tell the court, wanting to tell the judge what he thinks the judge wants to hear.
Assuming that the judge made a questionable choice, can you explain the prejudice to your client given the fact that he did not, the juror didn't participate in deliberations?
Yes, Your Honor, and I know the Commonwealth raised that in their brief. I would suggest, first off, this is structural error. I mean, this goes to the very integrity of the composition of the jury, even if it's not the composition of the jury through the lens of whether or not this juror actually deliberated. So I would suggest it's structural error, so therefore prejudice is not required. Having said that—
Can I ask you just to put a fine point on that? What's your best legal authority for that proposition?
Yes, I mean, I think narrowly it's a novel question of law, Your Honor, but I would point to the Weaver case, Weaver versus Massachusetts, I apologize. And I could read what the court said in that regard. Granted, it's not on this specific issue, but the court was talking about the idea of structural error in this context, that is to say, of jury selection. Or specifically it related to a public trial, but again, I would suggest it equally applies here. And the court in Weaver said, neither this reasoning nor the holding here calls into question the court's precedents deeming certain errors structural and requiring reversal because of fundamental unfairness. And then the court goes on, the reason for placing the burden on the petitioner here, however, derives both from the nature of the error and the difference between a public trial violation preserved and then raised on direct review and a public trial violation raised as an ineffective assistance claim. So there, the court was distinguishing, was saying, well, prejudice was required in that context because, of course, it's always required vis-a-vis ineffective assistance. But the court is saying, the court was careful, the U.S. Supreme Court was careful to point out that that did not change the nature of a structural error. And that is what we have here. It's a structural error. There is still harm, Your Honor, with respect to this error. So whether it's reviewed as a prejudice analysis or just sort of the innate problems, the innate damage that comes along with the structural, and that is it really distorts the entire voir dire process.
Can you go backwards then? Assume we disagree with you on the structural error component, and you started to answer the Chief's question about prejudice because you have to leapfrog our case law that says whatever the concern was about the error, we don't have a deliberating juror here. You have the juror that you're concerned about was an alternate. So what evidence do you have to suggest that, leaving aside the fact that it was an alternate, that this particular juror somehow infected the process up to the point of being chosen as an alternate?
I understand, Your Honor, and the Commonwealth points to that in their brief, the idea of the precedent from the Commonwealth. But the fact of the matter is there's ample precedent from the federal courts and the U.S. Supreme Court indicating.
Let's stick with our law. Let's stick with Massachusetts law. In the case that we said that when you have a situation here where it's the alternate that doesn't deliberate, what's the show of prejudice there?
Again, and so number one, the fact that this distorts the voir dire process as it did here. In fact, here it's that is a very lucid dimension of this, because in fact the Commonwealth joined with the defendant in opposing the placement of the seating of this juror. So really the entire voir dire process was distorted, and it alters the peremptory challenge strategy, Your Honor, without doubt. And that is also illustrated here. In fact, I would suggest, if anything, actually, the prosecutor, I think it just sort of worked out that way, but the prosecutor herself was adamantly, made an adamant argument to the judge that the judge had not followed the Batson protocol. And that is to say, because the judge said to both lawyers, really, said in essence that the judge thought that they were acting improperly, that both the defense counsel and the prosecutor. But the judge did so without any reference to the Batson protocol.
Can I ask you a quick question about that? Did the defendant ever try to exercise a peremptory on this juror?
I believe she said for cause, Your Honor.
Right.
And specifically said that for cause, not a peremptory.
That's the reason why I'm asking that. Is there a standing issue here that the prosecution is the one that raised the Batson source issue here with trying to use the peremptory and the back and forth with the judge that ensued? I'm just asking because I didn't see that the defense tried to exercise a peremptory on this juror.
I think that's a fantastic question, and what I would answer that is the way I would answer it is to say, well, it would have been futility at that point. And I mean, maybe not in this exact same context, but of course that is something that exists in the case law
yes.
up and down,
okay.
right? I mean, the fact is the judge had said that he felt that it was improper what both counsel were doing, and the prosecutor then maybe sort of took the lead in that regard. But and then it would have been obvious to any defense lawyer that pushing that aspect of it in your question, Your Honor, would have been futile. It would have been an exercise in futility. And also, just to go back to the previous question, it also forces defendants to litigate under what is really a compromised jury selection framework. And I think, again, that is seen here in particular, given that both sides clearly contested this. So we could look at these things.
I'm sorry, can you explain why it would have been futile for the defense attorney to try to exercise a peremptory? Okay, fine. If the judge isn't going to release for cause, then I want to exercise my peremptory on this prospective juror.
I would suggest, Your Honor, it was because the judge made it abundantly clear that the judge felt that there was some impropriety. I think the judge at one point said to both parties that the judge felt that the reason for this was because this juror was a minority.
I think that's a good point that the chief is raising, though, because what's unclear is perhaps you might be right about that. But this juror also said that I would have difficulty not having sympathy for the victim, which is a separate basis by which the defendant could have said, I'm not worried about the other component. I'm not worried about I'm worried about this direct causal connection to not being able to get the presumption of innocence that I'm entitled to because this person said I can't put aside my sympathy for the victim. And what about pursuing the peremptory on that basis? Why would that have been futile?
Because again, Your Honor, I understand, I think that that's another excellent question, but I do think that given the context here, I mean, I think that, first off, I would say I can't imagine a defense lawyer not challenging, not questioning it on the grounds of the fact that this man said that he, you know, I have a difficulty. I tend to think that Hispanics commit crimes, at least as to some areas, whether he meant geographically, whether he meant, you know, subject matter-wise, that's unclear from the record. But the fact of the matter is that reveals at a minimum some sort of implicit bias, some sort of something that was extant in this juror that is extraordinarily troubling. So I don't see a defense lawyer, any reasonable defense lawyer, sort of saying, well, okay, Your Honor, that's okay, but let me try this other aspect. And I think the judge made it clear that the judge was seating this juror.
But that doesn't answer my question, because you're focusing on the issue of what the juror said about thinking that Hispanics are more prone to commit crime. I'm speaking to the other statement where he said, I don't think I can put aside my sympathy for the victim. And why would that not have been something pursued by the defense? Back to the Chief's question of saying, okay, you might have thought it might have been futile to go down the path about the predisposition about certain folks doing crime, but why is it futile to not go and pursue that? Hey, he just said he's not going to be able to give me the benefit of the presumption that I'm entitled to under the Constitution.
Yes, sir. I don't have an answer. I mean, obviously I wasn't there, but it's the difficulty in trying a case and going through this process, and then you have something like this happen, which I would suggest is pretty rare. I hope.
But I don't want to lose you on this, because I know you said that your best case for prejudice is really under the federal jurisprudence that I'm assuming is cited in your brief. Can you move on to the issue of the prosecutor's closing argument? Because that's an interesting one for me, because, I understand that maybe he went a little bit too far about talking about a runner's high, but this testimony was elicited on cross-examination by defense counsel relative to the issue of cruelty and atrocity, and talking about the dopamine release upon being subjected to the trauma of being stabbed. Why is it that in response to what it is that was elicited on cross-examination, this goes too far? Because that's what the defense lawyer was angling for, right?
Well, I would suggest, first off, as to the prosecutorial closing arguments, the most troubling by far is the repeated theme that the defense expert was an advocate, not a witness. I mean, I would suggest, frankly, that's shocking. I mean, if it had been a passing reference, that would have been bad enough, but this was an entire thematic thread within the prosecutor's closing argument. And I think your question, Your Honor, what you're getting at is really, frankly, the least troubling aspect of all of it. I mean,
well, let's go through step by step. So the one about the client, your witness testified to the defendant being a client. So
absolutely.
So how is that statement
absolutely
improper?
And I know my brother raised that in his brief. So it's a fair point. Had it solely been limited to the idea that the reference to a client, that my client was this Dr. Sherry's client, I think we'd be here, not on that issue anyway. Huh? But it's the fact of it's that reference in the context of the argument, the claim that Dr. Sherry was in fact an advocate. And then combined with the fact that the prosecutor said, well, there's no evidence. The prosecutor said that there was nothing here to support his conclusions. Now, the prosecutor would be 100% free, is 100% free to say, well, here's what Dr. Sherry did, and here's what's lacking. Here's what Dr. Sherry did not consider, A, B, C, D, E, F, G, etc. I'm not making that argument. I understand that fully. 100% within his rights to do that. But that's not what the prosecutor said. What she said was, there's nothing here. There's nothing.
Do you think that falls within the hyperbole?
No,
No. Why
no,
not?
Your Honor, I don't. It's not merely hyperbole, because if you tell a jury that there's nothing here, then what you're really saying, what a prosecutor is really saying is, well, you can sort of disregard what all the hours that Dr. Sherry spent on this case and what Dr. Sherry testified to, you can just disregard it because there's nothing supporting his conclusion. I mean, again, would be 100, I don't think it's the same thing. I was reading this and I was thinking it's an interest of mine, archaeology. And you will hear archaeologists go back and forth, and sometimes they'll say, well, there's no evidence. There's no evidence of habitation in this particular site. And then another archaeologist would say, well, there's evidence. You might say that's not enough, but there is evidence of human habitation in the site. So those two things are quantitatively and qualitatively different.
Well, how does that then live within the context of the jury instructions that the judge gives, that closing argument is not evidence, further instructions to the jurors that they are the sole judges of the facts, that they also, if there's any conflict between what one of the lawyers says and what their memory of the evidence was, it's their memory that controls. How does that figure into what you're saying is some claim of error that warrants some kind of relief?
Yes, Your Honor. The first off, that was a standard instruction.
Sure.
It's not curative of the error, and the case law recognizes that. But I would say, actually, it makes it worse in terms of the advocate argument by this prosecutor. Why do I say that? Well, because if he's merely an advocate, the judge instructs the jury that, by analogy, the lawyers who are the actual advocates in the case, they're not to consider what the lawyers say for purposes, right, of evidence. That's not evidence, right? So if you apply that, if Dr. Sherry was an advocate, then the jury should completely disregard what he said. Now, there might be instances where that error could be harmless, right?
Now, I wonder if it was not error in this case because, and you know the record better than I do, so correct me if I'm wrong. I thought the prosecution's expert criticized Dr. Sherry for the number of times that he met with the defendant as tending towards being improper professionally, because you start as the professional feeling sympathy for the defendant as opposed to taking on an objective view of the diagnosis. So wasn't the prosecutor's statement of advocacy actually grounded in the evidence from the prosecutor's expert?
First off, it was not a statement. It was multiple statements to that effect, part of which then was the use of the term client, which again, for sure, if that was all that was said, that would not be improper. So, but it was a line of argumentation. And the answer is no, because, well, the prosecutor would be free to do that. Calling him an advocate is an entirely different thing. I mean, that's asking the jury to perceive his role as completely different from what his role actually was. Was the prosecutor free to point out that Dr. Sherry met too many times, too many hours? Oh, absolutely, sure. And then argue maybe from that, well, if his diagnosis, if his conclusions are so rock solid, Your Honor, then why did he meet so many times? That's fair game. No question.
Why isn't the reference to him as an advocate really shorthand for the idea that he was biased in favor of the defendant for the reasons given by the Commonwealth's expert?
Because the prosecutor didn't use the term bias. He said advocate. So, you know, I mean, I was looking through the case law on all of this, and I would suggest there's a case from this court, Rutherford, which was pretty analogous, pretty closely analogous, but that is different. In Rutherford, for example, this court held, well, it was non-prejudicial in the context. That was a diminished capacity issue. And I would suggest you can't have this be non-prejudicial here, because this case was tried on criminal responsibility, right? I mean, they acknowledged, everybody acknowledged that my client had committed the act. So I mean, if this is improper, and I would suggest, frankly, respectfully, it is wildly improper. There can be no harmless error in this context.
What is the standard, though? You just mentioned harmless error. If I remember correctly, this was unobjected to.
Correct. I'm sorry. So true. So, but again, I would suggest it constitutes a substantial risk, and especially for that part of the substantial risk test in Miranda, which focuses on, it goes to the very heart of the case, Your Honor. Thank you. Unless I think I'm over, unless there are any further questions.
Thank you.
Thank you very much.
Thank you.
Okay, Attorney Lynch.
Good morning. May it please the court. Travis Lynch for the Commonwealth, respectfully requesting that this court affirm the defendant's conviction for first-degree murder by deliberate premeditation.
Can we start with the juror question? I was surprised to see that you said in your brief that it was not an abuse of discretion to seat juror number 24.
Well, I think eventually the juror did state on the record that he could be fair and impartial.
Is the voir dire process supposed to be a situation where the judge questions and questions until the juror says what the magic words that he or she needs to say in order to be found to be indifferent?
I mean, I would say that at the beginning of the process, it's not as if he said, yes, I believe that this group is more, the beginning of this whole exchange is it seems as though the juror is unsure about it. And then over time, eventually the juror is established to unequivocally state that he can be fair and impartial. I understand what you're saying, but for whatever reason, the judge, I don't quite understand why the judge really wanted this juror to be seated, but the question, the answer that the juror eventually gave allowed the judge to find that the juror was fair and impartial. I mean,
So just the way you phrase that suggests an abuse of discretion. The judge was, and I'll just paraphrase what you've said, on a mission to seat juror 24. And even though the juror said, yeah, I think Hispanics may commit crimes on occasion, the judge then proceeded to cross-examine the juror to say, well, is that based on media? Setting aside the media, do you think Hispanics commit crimes more? And the obvious necessary answer was no. And then the follow-up is, can you be fair and impartial? It seems to me, and the prosecutor and the defense counsel both wanted juror 24 removed for cause. So
you're correct, yes. And
it just seems odd that the Commonwealth's position on appeal would be no abuse of discretion because the juror ultimately said the magic words.
I understand what you're saying. I don't know why the judge was doing this. We were concerned about this during the trial, but as I read the transcript, magic words were elicited, but I think the judge wanted to have a diverse jury. I think that's what was motivating this. But ultimately, none of this matters because the juror did not participate in deliberations.
I'm sorry, diverse jury, do we know what race or ethnicity? I'm sorry.
Of this particular juror, he was an African-American male.
I see, okay.
And I say that based on my own knowledge because I was at the trial. I wasn't here for this, but he was an African-American male.
So the guess is that he wanted a diverse jury, even if it meant that the diversity would count against the defendant based on the voir dire questioning.
I can't explain it. I can't explain it either, Judge.
You can't explain it. I guess the question for you, though, is my original question is I was surprised to see that the Commonwealth, after having, joined with the defendant to say, let's not seat this juror, the Commonwealth's position now is, it was not an abuse of discretion to seat this.
Right. Well, that's based on the fact that this is largely a credibility call on the part of the trial judge. So, I mean,
Sorry, there's two different issues here. There's whether it was an abuse of discretion not to strike for cause. And then there's a question of whether it was an abuse of discretion not to permit the Commonwealth to exercise its peremptory challenge. So are you switching to the second ground there?
well, I don't think I don't think the defendant can really complain about the Commonwealth's peremptory being denied because, it was the prosecutor who was said to have been exercising a peremptory for an impermissible purpose. We don't approve of that. But ultimately, none of this matters because the juror didn't participate in deliberations.
Just to stick with the issue, I think that the reason why it matters why the judge didn't permit the Commonwealth to exercise a peremptory is that the defendant has argued that the defendant also wanted to exercise a peremptory, and it was futile to do so because the judge's rejection of the Commonwealth's attempt to exercise a peremptory was sort of directed to both counsel. And so the denial of the Commonwealth's peremptory essentially was also the denial of the defendant's peremptory. So accepting that argument about waiver and preservation and so forth, accepting that for purposes of my question, we have two different questions here, right? There's the for cause one, and I've heard your argument about, the juror eventually said, I think I could be fair and impartial. So you're arguing that means it's good enough on the cause question. But can you address the separate question of whether or not there was an abuse of discretion in not permitting counsel for either side to exercise a peremptory?
So it seems as though the way that the judge articulated it seems as though he implicitly was finding that the challenges were being exercised, or the stated reasons were not genuine. At least that's how I read the transcript. And we don't agree that that's actually what happened, but given that it's an abuse of discretion, it seems as though it was basically a credibility call on the part of the judge. Now, we don't believe that our prosecutor was exercising a challenge for an impermissible purpose, but the trial judge, for whatever reason, thought so. And it seems as though that's a discretionary call on the part of the judge. Again, none of this matters because the juror did not deliberate. And the record is quite clear that the juror did not engage in premature deliberations. There was a very careful inquiry of the jurors every day, like to say, has anyone had any difficulty following the instructions? And no one ever reported anything about juror 24. And the no prejudice argument, I think, is much more straightforward and easier to reach than these complicated questions about standing and preservation and all of that. So going back to the for cause issue about an indifferent jury, the jury trial right, or the indifferent jury trial right, is the deliberating jury. Alternates don't seem to play into that at all. So at the end of the day, the answer to all these questions is juror 24 did not participate in deliberations. His presence on the jury did not affect the outcome of the trial. And we agree that, with the benefit, now that we're arguing about this, we really do wish that the judge had just excused this juror. But any error was harmless. It was not prejudicial under the circumstances. There's a variety of closing argument claims about the advocate line.
Can I ask you to first address the argument that this is structural error?
I don't think that it's structural error because the jury trial, I would say that because the juror did not participate in deliberations, it's not a structural error. It's like in the peremptory challenge cases, if a defendant is denied a peremptory challenge and the juror participates in deliberations, the court automatically reverses the conviction without inquiring into harm because you can't assess harm after the fact. But Smith says that if the juror does not participate in deliberations, then there's no harm to the defendant. So it seems as though it turns on whether the jury participates in deliberations. Because he didn't participate in deliberations, it seems to drop it down from a potential structural error into something else. So does that address your?
It does, so go ahead with the closing argument.
Yes, thank you. So as was suggested during defense argument, the argument about Dr. Sherry being an advocate as opposed to a neutral evaluator is entirely grounded on the specific testimony of this case. It's not like it was ad hominem name calling like some of the case law that's cited in the defendant's brief. It was largely based on Dr. Zale's critique of Dr. Sherry's methodology. There's even a discussion, I think it's on volume 7, 121. The words advocate and advocacy are used during the testimony and also by the questioning of the prosecutor. And I would submit that it's quite clear that Dr. Sherry was selective with the data points that he used in forming his opinion. With respect to the argument about the runner's high and that whole discussion, the defense marshaled the evidence that the victim would have had endorphins in his system. And so she argued that the murder was not extremely atrocious or cruel. And the prosecutor retorts, that's ridiculous because, I mean, you can see for yourself in the video what happened to the victim.
I'm not so troubled by that because I do think that they brought that on with the questioning and the implication that they were going for with the cruelty and atrocity prong. But if we go back to the criticism of Dr. Sherry, the entire ball of wax for the defendant is criminal responsibility. Should the Kozik line of cases and the calculus of whether or not the prosecutor goes over the line, should that also be a function of what kind of a case it is? Because this is the only arrow in the defendant's quiver. I mean, the murder was on video. There was no question that he had done it. I didn't get to with your brother talking about the issues with the suppression, but assuming that the suppression comes in, there were statements that the defendant makes. So this is the only avenue that the defendant has to either minimizing or escaping criminal liability for this.
You're absolutely right that this was, I mean, there was a half-hearted attempt to defend it on extreme atrocity or cruelty grounds, but you're right that it was mostly about it was entirely about criminal responsibility, really. And I think that's already in the case law, like Shelley, because there's case law that says this closing argument went to the heart, or the claimed error in the prosecutor's closing went to the heart of the case. So I agree with you that in principle, if a prosecutor were to improperly argue that the defense expert in a criminal responsibility case was bad or what have you, then that increases the risk of reversal on appeal. So I completely agree with you on that. I think Shelley says that. And the reason in Shelley why the misstatements about the defense expert's credibility were so important was that was the only defense for that defendant. So I agree with you on what you're saying. But there's no error here, and the Commonwealth is allowed to contest the credibility of a defense expert in a criminal responsibility case.
Is there no error here because of the standard of review, because it was unobjected to? Would it be a closer call if it were?
Well, the presence or absence of an objection just diminishes because there's no objection, it just means that it's much harder for the defendant to get a new trial because of this. So because we're under 33E, it's substantial likelihood.
Right.
I mean, I think that the way that the court analyzes these claims is there's an error regardless of whether there's an objection. That's how I understand the closing argument case law. Mm-hmm. But the fact also that there's no objection shows that at least when in Kozik, the court even suggests the absence of an objection itself suggests that this wasn't really that bad. My point is, on this very specific record, given the way that the testimony came out, this was an entirely appropriate argument, especially when Dr. Sherry's even using the word client. The testimony of Dr. Saleh, I think, gives in great detail what the problem is with Dr. Sherry. If we hadn't elicited testimony from Dr. Saleh of that character, I think this looks different. But here, it's completely supported by the evidence. With respect to, if I could just move on, there's just to touch on very briefly the autopsy photos. There was an objection to this below. I don't think that autopsy photos are excluded just because the defendant is running an affirmative defense. The Reyes case is a self-defense case. No error in letting in the autopsy photographs. The judge articulated on the record essentially the standard for assessing whether autopsy photos should come in or not. And he, in fact, I believe, excluded some. So it's not as if the Commonwealth was allowed to just stampede the defendant with all this highly inflammatory evidence. Also, as you know, the incident is on video, so I don't see how the autopsy photos by themselves would create much more. I mean, I think that's enough said about that. With regard to the suppression issue, the judge clearly articulated the correct standard. He placed the burden of proof on the Commonwealth. He found that the statements were voluntary beyond a reasonable doubt. And there are cases in which the defendant has some mental health problem, but the statements are voluntary anyway. I don't see, there's no challenge to any of the findings is clearly erroneous. And the legal conclusions seem to flow naturally from the findings of fact. Very briefly about 33E, the existence of a mental health condition on the part of the defendant is not alone a sufficient reason or justification for reducing the verdict. You've seen for yourselves this video. This is clearly premeditated. The jury were properly instructed on all the elements. They received criminal responsibility instruction. They received a mutant chapel instruction about the consequences of a not guilty by reason of lack of criminal responsibility verdict. The jury only found the defendant guilty of premeditation, not extreme atrocity or cruelty, and they acquitted the defendant of the other count in the indictment. Justice here was done. I'd ask that you affirm.